Hello everyone, my name is Alex Slane and I represent the Eastern New York Youth Soccer Association. The Eastern New York Youth Soccer Association was founded in 1913 and is dedicated to enhancing the game of soccer for the youth in their community. On Sunday, May 30th, 1999, it was a hot and sunny day in Glenville, New York. Mr. James Sutton, the plaintiff, and his wife were watching their son play in a soccer tournament at Malik Park. The defendant, my client, decided to set up a team tent about 30 to 40 yards behind the goal because it provided shade for the boys and their families. At Malik Park, there are 16 soccer fields in total. 15 are lined up, one in front of the other, and the 16th one is situated off to the side. There were hundreds of players at this particular tournament, and they were using at least 5 fields during the tournament at any given time. After Mr. Sutton's son's second game of the day, the family decided to head towards the tent to get out of the sun and get something to eat. As Mr. Sutton bent down to retrieve a sandwich from his cooler, he was hit in the chest and sustained injuries to his knee from a soccer ball that was kicked from the field over. He immediately fell to the ground and claims that he sustained injuries. Mr. Sutton decided to file a complaint of negligence due to his injuries. He is seeking to recover damages from the team sponsoring the event, the participants in the tournament, and the boy who kicked the ball at him. Later in the case, Mr. Sutton admitted to knowing that the boys were on the field practicing next to him. However, when he walked past them, he didn't think anything of it and just kept walking. The court determined that Mr. Sutton assumed risk when he decided to be a spectator on the sidelines of his son's game, and therefore the Eastern New York Soccer Association is not responsible for the injury sustained due to the doctrine of assumption of risk. The plaintiff, Mr. Sutton, claims that the New York Youth Soccer Association unreasonably enhanced the likelihood of sustaining an injury due to where they decided to place the team's tent. The case was appealed, and the plaintiff argued that he was not a voluntary spectator of the game where the foul ball was kicked, so he could not have been found to assume risk. My client's argument being that there was an adequate room to remain on the sidelines where the plaintiff was originally seated, so he didn't have to go to the team's tent. The real legal question in this case being, can the New York Youth Soccer Association be found liable for Mr. Sutton's injuries? And did Mr. Sutton assume risk when he walked onto the field that day to watch his son play soccer? There are various outside parties who are affected by this case. The first being the employees of the Eastern New York Youth Soccer Association. They are counting on the association to keep their secure jobs. Another stakeholder in this case would be the community. The Eastern New York Soccer Association is a non-for-profit organization, and it really means a lot to the youth in their community, so it would be a huge loss to that community if they were to lose this organization. This case leaves the Eastern New York Youth Soccer Association in an ethical dilemma. They do not want their club to face a drop in earnings due to parents not wanting to sign their kids up due to injuries. They also do not want their strong reputation to be hurt by these claims. They are a non-for-profit organization and do not have the extra funds to pay fines or fees to the plaintiff, as the money from their participants goes back into the soccer club for improvements. When we compared this case to a baseball game, the same rules applied. This is known as case law, or a law established by the outcome of a former case. The owner cannot be found responsible for a spectator who decides to leave his seat to go to the concession stand or the bathroom, or in our case, go to the team tent to eat lunch. The plaintiff assumes risks in this situation when players are engaged in the field. The risk at sporting events is seen as, quote, fully comprehended or perfectly obvious, quote, and the participants' consent will be assumed. It was decided that the soccer fields do not need to supply nets to put around the fields for the spectators because the soccer ball is bigger than a baseball and it moves slower than a baseball. The plaintiff has been in attendance for hours and had the knowledge that the boys were on the field next to him kicking the ball. Our opponent's argument being that he was not watching that specific game where the foul ball was kicked, so he could not consent. However, this did not stand up in court. It was found that the 16-year-old boy who kicked the ball towards Mr. Sutton did not do so maliciously or intentionally. This case would be considered an unintentional tort because it was an accident that led to an injury. It was even questioned whether or not Goss, the 16-year-old who kicked the boy, could even be, quote, found arguably negligent, quote. It is also known fact that the plaintiff was a frequent observer of soccer, as his son has played for 14 years, and that he should know what the risks are when spectating. A summary of judgment was granted to all respondents. On appeal, the court confirmed that the doctrine of assumption of risk applies to all in attendance, including spectators. The final ruling in this case was that the New York Youth Soccer Association cannot be found liable for Mr. Sutton's injuries and that he assumed risk when he entered the tournament that day. This case is important to the understanding of law because it was a defining moment in all sports-related businesses and teaches us a lot about negligence and responsibility.